Most people believe a property deed is just a piece of paper to sign and file away. But one man learned too late that a single unsigned addendum during his arranged marriage settlement opened a succession claim that would cost him crores and split his joint family for years. Let's set the scene. Rajesh and Priya's arranged marriage was settled in 2012. Rajesh's father owned a Delhi property worth roughly 2.5 crore rupees, a three-generation home where his brother, sister-in-law, and their children also lived. Before the marriage, the family lawyer drafted a basic settlement deed outlining each member's occupation of the property. Rajesh's father signed it. Rajesh didn't. Fast forward to 2018. Rajesh's father passes away. His will clearly named Rajesh as primary beneficiary of the property, standard for the eldest son in a joint Hindu family. But here's where the mistake surfaced. Rajesh's unmarried sister, who had been living on the property, filed a succession claim arguing she had equal inheritance rights as a daughter under the Hindu Succession Act, 1956. Now, honestly, most people get this wrong. They think daughters have no claim to joint family property. That's outdated. Under the Hindu Succession Act, as amended, a daughter is a co-parcener, meaning she has an equal stake in ancestral property by birth, not just by will. But the catch is timing and whether the property was already partitioned. Because that unsigned addendum never clarified whether the property was jointly held or individually owned, the family court couldn't easily determine if partition had occurred. Rajesh's sister argued no formal partition had taken place, therefore she held equal rights. The case dragged for 4 years. Rajesh spent 8 lakh rupees in legal fees. The property sat in litigation limbo. The verdict? The court ruled a partial partition. Rajesh retained majority rights, but his sister was awarded a defined share. More critically, the court ordered a professional valuation and a formal deed partition, something that should have happened in 2012. The cost of that oversight, legal fees, delayed sale opportunities, family trust destroyed. Here's the key takeaway that honestly most joint families miss: get a clear, signed partition deed or a registered gift deed before any marriage settlement or major life event. Under the Hindu Succession Act, daughters, sons, and widows all have defined rights, but only if the property's ownership status is crystal clear in writing. If you are in a joint family and property is involved, whether it's arranged marriage, will planning, or inheritance, don't assume the deed is just a formality. Get a qualified property lawyer to review it. The few thousand rupees invested upfront could save you crores and years of courtroom battles. That's the lesson Rajesh learned far too late. We cover real family law stories and explainers every week. If succession disputes or property inheritance rules matter to your family, subscribe so you don't miss the next breakdown.